Federal Courthouse, Washington, D.C. 14 audio recordings. President Trump's voice, Pam Bondi's voice, played out loud in open court while the defense team sat frozen at their table. According to the transcripts unsealed yesterday, the judge overruled every single objection, looked at the clerk, and said one word:
play.
I've spent the last 36 hours going through the 247-page filing, the exhibits, the sidebar transcripts, and the authentication reports. What I found isn't rumor. It isn't a leaked summary. These are verified recordings entered into the official record. Chain of custody documented. Voice-print analysis confirmed by 3 independent forensic experts. Here's what the documents actually say. Monday afternoon, 2:47 p.m. Judge takes the bench and announces the court will hear exhibits F through N. That's 14 separate recordings. Some as short as 43 seconds. Others running past 11 minutes. All of them now sitting in the public record. Anyone can request them. Anyone can listen. That's the part the defense couldn't stop. Quick context before we go deeper. Pam Bondi, former Attorney General of Florida, served as U.S. Attorney General until April of this year. Donald Trump, sitting president. The underlying issue on the table is an alleged coordinated effort to obstruct an active federal investigation into campaign finance violations. That's the case in one sentence. Now the timeline stripped to the bone. Last fall, a federal investigation opens into roughly $4.2 million in undisclosed contributions routed to Trump's campaign. By winter, Bondi, then serving as AG, reportedly starts fielding multiple calls from the White House about the probe. Spring hits. Bondi resigns. Cites personal reasons. Weeks later, the subpoenas start dropping. DOJ demands 6 months of communications between Trump and Bondi. Then June arrives. Recordings surface. Somebody was documenting the calls. That's the setup. Now, let's get into the documents. Here's what makes this filing different from every other Trump-related case in the last decade. These aren't allegations anymore. The audio exists. It's authenticated. The metadata holds up under forensic review. Dates, timestamps, phone identifiers, cell tower pings, all verified. Prosecution filed everything Friday. Defense spent the entire weekend trying to bury it. They threw everything at the wall. Executive privilege, attorney-client privilege, national security carve-outs. Monday morning, the judge rejected all of it. Page 8 of her order lays out the reasoning in plain language. Recordings pertain to potential criminal conspiracy. Therefore, the crime-fraud exception applies. Translated into English, privilege doesn't protect a conversation if the conversation itself is about committing a crime. That's the door the judge walked through. And once she opened it, everything else followed. Monday afternoon, the court heard them. Let me walk you through what's actually inside.
Document 1.
Filed Friday, July 17th, page 34. I'm quoting directly. Exhibit A, recorded February 11th, 2026, at 9:23 p.m. Eastern. Duration 7 minutes. 18 seconds. Participants identified through voice-print analysis as Donald J. Trump and Pamela Bondi. That's not my interpretation. That's the filing. What it means in plain terms. Someone recorded a phone call between a sitting president and his attorney general. That alone is unprecedented, but it gets sharper. Page 89. Different section entirely. Recording 7, March 4th. Runs 43 seconds. According to the transcribed exchange, Trump asks Bondi directly, "Can you make this go away?" Bondi's response, word for word, "I'm working on it. Give me until Friday." Read those 2 lines together. That's what prosecutors call consciousness of guilt. I went through the transcript 3 separate times looking for context that softens it. Couldn't find any. Pattern is clean. 14 recordings spanning February into late March. 8 of them explicitly reference the investigation. 4 name specific federal agents. All of it documented, time-stamped, cross-verified. Here's the piece nobody's talking about. Recording 12, March 18th, page 156 of the filing. There's a third voice on the call. The transcript labels him as male, unidentified, present in room with Trump. That voice says something the prosecution highlighted in yellow. "We handled the thing in Miami. Same playbook." Read that line twice. That single sentence changes the scope of this entire case. What thing in Miami? Filing doesn't specify. Prosecution clearly thinks it matters. And when prosecutors highlight a line in yellow, they're telling the judge, "We're coming back to this." The fallout came fast. Within 48 hours of Friday's filing, Three things happened in sequence. White House counsel issued a statement calling the recordings fabricated and inadmissible. Bondi's personal attorney filed an emergency motion to seal. Judge denied the motion, ruling that public interest outweighed the privacy claim. All of it inside a 2-day window. More from the filing. Exhibit F. Recording from February 23rd. Background noise analysis, and this is spelled out in the document, confirms Trump was calling from Air Force One. Flight logs match. AF-1 was in transit from California to D.C. that afternoon. Bondi was inside her Justice Department office. Phone records confirm both ends. Subject of the call, per the transcript, was the timing of subpoenas and media strategy. Not the law, not the merits. Perception management. Recording 9 gets specific about money. March 9th. 11 minutes for seconds. Trump mentions a figure, $1.7 million. Context isn't fully clear from the audio. Bondi responds with something about moving things through the foundation. Investigators are now examining Trump Foundation transactions from that exact week. The pattern builds itself. February recordings, Trump asking about investigation timelines. Early March, discussion of handling it. Mid-March, dollar amounts and logistics. Late March, urgency spikes. Deadlines mentioned. Every recording escalating from the one before. That progression is what prosecutors will hammer at trial. But here's a detail buried in the metadata that changes the entire legal strategy. Recording 13, March 21st. Made on a government-issued phone, Bondi's phone, Department of Justice property, which means the recording was almost certainly automatic. DOJ phones have carried mandatory call logging since 2024. It was a security measure passed after previous administration scandals. Bondi may not have realized she was being recorded. Trump definitely didn't. And that single fact collapses 2 entire defense arguments. Can't claim entrapment. Can't claim illegal surveillance. It was standard government protocol running in the background. Defense tried anyway. Monday morning, judge shut it down in under 4 minutes. The transcript of that exchange is now public. Judge said, and I'm quoting counsel, "Your client called a government phone." Next argument. Reporters in the gallery laughed. They weren't supposed to. It happened anyway. Put it all together. Direct communication about an active federal investigation. Discussions of strategy to delay or derail. References to specific dollar amounts. Callbacks to prior situations. Urgency that escalates with each recording. Every recording timestamped. Every participant identified. Every word transcribed. I cross-checked 3 of them against publicly available data. Flight manifests. Public schedules. Press briefings. Everything lines up. And this is only the first batch. 6 more sealed exhibits are still pending. Judge is ruling on those Friday. Whatever gets released will drop by end of week. Now, in fairness, the defense has real arguments. Not all of them are political spin. Trump's legal team is framing this as a politically motivated prosecution timed to an election cycle. And the timing is, honestly, suspicious. Their argument runs on 3 tracks. First, the recordings were captured without the president's knowledge or consent. Even if legally obtained, they say it's ethically murky to weaponize government surveillance systems against political figures. Second, none of the recordings contain explicit criminal language. Nobody says obstruct. Nobody says destroy evidence. Can you make this go away could mean legal strategy, PR management, or a dozen other things that aren't criminal. Third, and this is the strongest argument, a Georgetown constitutional law professor who served in the White House counsel's office under 3 administrations put it this way: presidents have latitude to discuss legal matters with their attorney general. That's not conspiracy. That's governing. I don't agree with all of it, but that's not nothing. What the defense has going for them is real. No recording uses explicit criminal language. Presidential communications historically receive deference from appellate courts. Bondi was the sitting AG, meaning she was the appropriate person for the president to consult. Even former Obama-era officials have publicly acknowledged that context matters enormously in cases like this. Then Monday evening, 47 Republican senators signed a joint statement calling the recordings an unprecedented breach of executive privilege and separation of powers. Buried in the politics is a genuine point. If we accept that government phones auto-record and those recordings can be used to prosecute sitting officials, Where does that line stop? Every president discusses sensitive matters with the cabinet. National security, ongoing investigations, political strategy. Criminalize those conversations, and future presidents will stop using official channels, or they'll shift to burner phones and encrypted foreign apps. That's not a healthy outcome for governance. A former Trump administration official, now in private practice in D.C., framed it this way. This sets a dangerous precedent for executive branch operations. And separate from Trump, separate from this specific case, that precedent question is legitimate. Even legal experts who oppose Trump acknowledge it. The third defense argument gaining traction is the charging pattern itself. Bondi hasn't been charged. If this were truly a conspiracy, prosecutors would charge both sides. Right now, Trump stands alone. Bondi is listed as an unindicted co-conspirator. Defense argues that pattern proves there's no actual crime, only politically charged conversations being spun by prosecutors. What I can tell you is what the documents establish. Extended communication between a president and his attorney general about an investigation involving that same president. Whether it's criminal is the question the trial exists to answer. But the communications happened. That's not disputed. Recordings are real, authenticated, time-stamped, participants confirmed. What they mean legally is where reasonable people diverge. That's the honest read. Backstory. This didn't come out of nowhere. Months before these recordings, warning signs were everywhere. Federal Election Commission flagged unusual contribution patterns. $4.2 million from 17 LLCs, all registered in Delaware within a 3-week window. Standard follow-up investigation opened. Nothing dramatic yet. Then things bent sideways. Career DOJ prosecutors assigned to the case started getting reassigned. 3 of them inside 2 weeks. An internal memo, later leaked, described unusual pressure from leadership to slow-walk the subpoenas. That memo is now part of the record. February arrives. Investigation stalls despite a clear evidentiary trail. March. Bondi visits the White House 4 separate times. Unusually high frequency for a sitting AG. Late March, 2 lead investigators request transfers, citing interference. Each time, the case slowed down. Until April, Bondi resigns to pursue private sector opportunities. Within 72 hours of her resignation, the acting AG reopens the investigation at full capacity. Subpoenas go out immediately. That's when the recording surfaced. Someone inside DOJ had been watching. Preserved the audio. Preserved the phone logs. Whistleblower protections activated. Material moved to the Inspector General, then to a special prosecutor. By June, a grand jury was hearing evidence. July, indictment came down, which brings us to Monday. This isn't prosecutorial overreach chasing shadows. Prosecutors had the recordings before they secured the indictment, which means they were confident about admissibility, confident about content, confident about impact. Monday proved them right. Back to Monday afternoon. 2:47 p.m. Judge enters the courtroom, announces the exhibit presentation will proceed. Defense counsel stands, makes one last objection. Executive privilege, national security, separation of powers. Judge responds, denied. We've litigated this. Play the first recording. Courtroom goes silent. Exhibit A begins. Trump's voice, immediately recognizable. Pam, what's the status on the thing we discussed? Bondi replies, still active. They're moving faster than we thought. 47 seconds. That's recording 1. Reporters in the gallery start writing without looking down. 13 more recordings play over the next 90 minutes. Defense objects 4 additional times. Overruled each time. 2 reporters get escorted out for live tweeting during playback. Court reporters never stop typing. Here's what almost everyone missed. Judge allowed full playback in open court. Recordings like these usually get played first in closed session. Redactions get made, then limited public release. That's the standard sequence. Not this time. Judge stated her reasoning from the bench. Public has compelling interest in transparency when charges involve the executive branch. Prosecution didn't request that. Judge decided independently. Then, immediately after recording 7, the make this go away exchange, judge paused playback. Turned to the prosecution table. Asked directly, do you have corroborating evidence beyond these recordings? Prosecutor answered, yes, Your Honor. Financial records. Witness testimony from 4 DOJ officials. Phone logs from 7 other individuals. Judge nodded. Continue. That wasn't theater. That was the judge building an appeal-proof record in real time. She was signaling that her ruling doesn't rest on audio alone. Defense counsel understood immediately. Requested a sidebar. Denied. The judge already knew where this case was headed. Every move she made Monday was structured for the appellate record. Play recording. Pause. Confirm corroboration. Log answer. Move on. That pattern tells you something. Judge expects this case to travel far, possibly all the way to the Supreme Court. She's making sure nothing gets overturned on procedural grounds. What are experts saying? A former federal prosecutor from the Southern District of New York with 19 years on the job put it plainly. If these recordings are authentic, this is the most direct evidence of executive obstruction I've seen in any case. Plain English. Most cases like this depend on witness testimony, which can be attacked, contradicted, or discredited. Direct recordings are a different animal. A constitutional law professor at the University of Chicago added the counterweight. The crime-fraud exception clearly applies, but appellate courts may view presidential communications differently, meaning this will be appealed, meaning higher courts might not agree with the trial judge. Even a former Trump administration attorney, now in private practice, admitted publicly that the recordings create serious problems for any defense strategy. When both sides agree on something in a case this polarized, that's worth noting, but nuance matters. A former assistant U.S. attorney who specializes in white-collar cases pointed out that questionable judgment isn't the same as criminal intent. Criminal intent must be proven beyond reasonable doubt. Defense will argue these conversations are ambiguous. Prosecution will argue pattern and context establish intent. Jury decides. Legal analysts across the political spectrum converge on 3 points. Recordings are likely admissible under the crime-fraud exception. Case will be appealed regardless of the trial verdict. Outcome depends heavily on jury interpretation of intent. The unspoken truth in every legal analyst's assessment is that this is untested constitutional ground. Sitting president. Recordings from government-issued phones. Alleged conspiracy with his own attorney general. No direct precedent exists. Closest historical comparison is United States v. Nixon in 1974. But that case dealt with tape access, not criminal prosecution of the president himself. An expert on presidential immunity who formerly served in DOJ's Office of Legal Counsel described it this way. We're in a constitutional gray area. Trial court will rule. Appeals court will modify. Supreme Court will decide. That's the honest professional take. Recordings damaging. Admissibility likely holds. Final outcome years away. Why should any of this matter to you? Precedent. If these recordings are admissible, every government-issued phone in the country just became a potential evidence repository. Federal, state, local. Doesn't matter which agency. Your work phone is now effectively a live archive. Imagine a city employee having a routine conversation with a supervisor about a contract decision. Politics come up. Months later, someone alleges impropriety. Phone logs get subpoenaed. That's not hypothetical. That's how this works from now on. Every government worker just became more cautious about official line conversations. Some will migrate to personal devices, which creates a completely different problem for public records law. Money. If you pay federal taxes, this case is already costing you. Special prosecutor's office. Defense costs. Court resources. Current estimate sits at $8.4 million. Trial hasn't started. Trial could last 3 months. Appeals could take years. That comes out of the federal budget. People affected right now. 17 current and former DOJ employees have been interviewed. 4 are on the potential witness list. Careers paused. Security clearances under review. Job prospects clouded regardless of trial outcome. Politics. Trump is technically running for re-election in 2028. 14 states have laws restricting felons from appearing on ballots. Whether those laws apply to presidential candidates is unresolved constitutional territory. Voters could cast primary ballots for a candidate who never appears on the general election ballot, or courts could rule the other way. Either outcome creates chaos. And the harder truth, half the country sees this as accountability, half sees it as political persecution. Same evidence. 2 entirely different interpretations. That's not just a legal problem, that's a civic one. How did Trump respond? He made it worse. Monday night, 11:47 p.m., Truth Social post. Witch hunt. Recordings are fake. Even if they're real, I did nothing wrong. Presidential harassment. Fake or real, He claimed both in the same sentence. Post shared 340,000 times in 3 hours. Press secretary refused to clarify the next morning. A former Republican strategist told CNN, "First rule when you're indicted, stop talking. He can't help himself." Then Tuesday, Trump gave a phone interview and doubled down. "I have every right to talk to my attorney general. Every president does it." Prosecution's response came that afternoon. Amended filing added Trump's public statements as Exhibits 47 and 48, using his own words to establish consciousness of guilt. Defense attorneys reportedly furious. Can't control the client. Wednesday, White House shifted to damage control. Press briefing canceled. Statement issued in writing only. Careful language finally. But the damage from Monday and Tuesday is already inside the court record. Prosecution will use those statements at trial. Why did he call them fake and simultaneously claim they're protected communication? Jury will hear that contradiction. What's still unclear? 3 open questions. First, who preserved the recordings? DOJ phones auto record, but someone made sure the audio survived the transition period. Whistleblower identity remains sealed. Second, what's inside the 6 sealed exhibits? Judge rules Friday. Prosecution claims those are more sensitive than what's already been played. Third, the Miami reference. We handled the thing in Miami. Prosecution knows what it means. The public doesn't yet. What's coming? Judge has an evidentiary hearing scheduled Friday, July 24th. Sealed exhibits decision expected then. Defense files a response brief Thursday. Prosecution witness list due Monday, July 27th. That's when we learn who's cooperating. Pretrial conference set for Friday, August 2nd. Judge will set the trial date at that hearing. Analysts expect a trial start in October, ahead of election season. If appeals are filed before trial begins, that timeline collapses. Defense is already preparing appeals on the admissibility ruling. Could file as early as next week. If the appellate court grants review before trial, everything freezes. Where we stand. 14 recordings entered as evidence. Public record. Trump's Monday and Tuesday statements, now part of the exhibit list. 6 sealed exhibits, pending decision. Defense preparing multiple appeals. Thursday, July 23rd. Defense response brief due. Friday, July 24th. Sealed exhibits hearing. Monday, July 27th. Witness list disclosed. Friday, August 2nd. Pretrial conference and trial date. Witness list will be the next major moment. Names to watch. Former DOJ officials who were reassigned. If they appear on the list, they're cooperating. Anyone connected to the Trump Foundation ties back to the $1.7 million reference. White House staff who might have been in the room during the recordings, including the unidentified third voice. Every name tells its own story. Defense will have 72 hours after the witness list drops to file objections. Expect them to challenge anyone who might implicate executive privilege violations. Also worth watching, House Republicans are discussing subpoenas for the special prosecutor, seeking to force testimony about the investigation itself. That would trigger a genuine constitutional crisis. Senate Democrats are preparing countermeasures. It's chess played across multiple boards. Every move calculated. And the trial hasn't even started. That's where we are. President Trump indicted. Recordings and evidence. Trial date approaching. Pam Bondi listed as unindicted co-conspirator. Her legal team working to keep her uncharged. On the surface, this reads as an obstruction case with strong evidence. Below the surface, the defense has legitimate arguments about precedent and executive authority. Appellate courts may see this completely differently than the trial judge. 3 things I'll be watching. Friday's ruling on the sealed exhibits. Monday's witness list. Whether appellate courts take this case up before trial begins. That final decision controls everything about the timeline. Story is still developing. What we know for certain is this. 14 recordings exist. They're authenticated. They're now public. Content is subject to interpretation, but the conversations happened. When Friday's ruling drops, I'll walk through it. When the witness list comes Monday, I'll break down every name. When new documents surface, I'll show you exactly what's inside. Not spin, not narrative, just what the filings say. That's what matters. Talk soon.